Article 26 of the Family Code of the Philippines. Article 26 addresses two key provisions related to marriages involving Filipino citizens and foreign nationals. Here's a detailed explanation. Text of Article 26. All marriages solemnized outside the Philippines, in accordance with the laws in force in the country where they were solemnized, and valid there as such, shall also be valid in this country, except those prohibited under Articles 35, 1, 4, 5, and 6, 36, 37, and 38, where a marriage between a Filipino citizen and a foreigner is validly celebrated and a divorce is thereafter validly obtained abroad by the alien spouse capacitating him or her to remarry. The Filipino spouse shall have the capacity to remarry under Philippine law. Key provisions. 1. Recognition of foreign marriages. General rule. Marriages solemnized outside the Philippines are valid in the Philippines, if they are valid under the laws of the country where the marriage took place. Exception. The marriage is invalid if it violates the following prohibitions. Article 35. Lack of essential or formal requisites. Bigamy, mistaken identity, and marriages under duress or fraud. Article 36. Psychological incapacity. Article 37. Incestuous marriages. Article 38. Marriage is void for being against public policy, e.g., marriages between step-parent and stepchild. 2. Divorce obtained abroad. Applicability. This provision applies to marriages between a Filipino citizen and a foreigner. Key points. If the foreign spouse obtains a divorce abroad that allows them to remarry under their national laws, the Filipino spouse is likewise allowed to remarry under Philippine law. This ensures fairness, preventing the Filipino spouse from being perpetually bound to the marriage when the foreign spouse is not. Supreme Court Clarification, Republic v. Manalo, GR number 221029, April 24, 2018. The Supreme Court ruled that even if the divorce is initiated by the Filipino spouse, as long as the foreign spouse is capacitated to remarry under their national laws, the Filipino spouse may also remarry. Practical implications. 1. For Filipino foreign national marriages, marriages performed abroad are generally recognized in the Philippines, except if they fall under the prohibited categories. 2. For divorce cases, the Filipino spouse must provide proof of the foreign divorce decree and the foreign law that allows the foreign spouse to remarry. A court recognition of the foreign divorce is required for the Filipino spouse to remarry. Notable cases. Republic v. Orbecido III, GR number 154380, October 5, 2005, established that a Filipino spouse can remarry if the foreign spouse obtained a valid divorce abroad. Republic v. Manalo, GR number 22129, April 24, 2018, affirmed that Article 26 also applies if the Filipino spouse initiated the divorce abroad. Key takeaways. Article 26 provides a framework for recognizing foreign marriage as a